supporter of BICL for many years, and you're a member of the Investment Treaty Forum Advisory Board. And you also happen to be a Canadian, so it looks like I have a pro-Canada bias in selecting the speakers, but I'm sure that the quality of your moderation will be exceptional, and so the floor is yours. So I would like people who are on the panel to ask them to share their videos to make it more like a real-life experience, but keep your microphones on mute, please.
Yari, just one point. My video is blocked from the host for whatever reason, so I can't turn it on. So maybe if someone can.
Okay. Yeah, we'll ask Liam if I don't know whether you can do anything about. How about Louise? Louise, can you share your videos? Okay, now it's fine. Okay.
Resolved.
Thank you. And now it's time for me to disappear and leave you in the capable hands of Robert.
Thank you so much, Jarek. And indeed, I am Canadian, and you can probably see on the wall behind me the snowshoes at my country home in Canada. I've come home to visit my parents, and I'm actually in quarantine. But it's a fantastic conference that Jarek has put together, and I'm delighted to be a part of it. I'm also particularly delighted to be chairing the panel this afternoon, because the topic is one of great interest to anyone who practices this area of public international law. And we are very fortunate in our three panelists and presenters today to have three individuals who not only are practitioners, but also are thought leaders in this area of law and in investment treaty arbitration. We've been told that there's no need for introductions because bios are available in the materials, but I'm happy to say that I have variously known and worked and taught and so on with each of our panelists, and so we're in for a really great session today. Now I'm going to describe the order and just one word on what everyone is going to be speaking, and then I'm going to take 60 seconds to set the stage. We are going today to start off with Roland Ziadeh, and he is going to give us a comprehensive overview of this particular area of public international law and state responsibility. He is, I understand, going to focus on the classic public international law issue in terms of state responsibility, which is consent. And of course, states only limit their ability to act autonomously in relation to customary international law, use cogents, and where they've specifically consented in other means, for example, by treaties. So Roland is going to look at that important principle and how that plays out in terms of regulation. Then we are going to have Inga Martinkute, who's going to talk to us about the importance of having a comparative element to this analysis, and a relative one as well. Not every state is the same, not every state has the same resources, the same functional capacity, and therefore she's going to talk to us about how we go about evaluating regulation by the state. Is it a one-size-fits-all, or is there some comparative relative element to it? So we'll look forward to that. And then we will have Louise Woods draw all these together by reference, all these thoughts together by reference to some of the current case law that is being generated by tribunals dealing with these issues under investment treaty arbitration. So before we turn to Roland, I'm just going to, as I said, spend 60 seconds talking about this. Now, of course, there is, despite NGOs and journalists, there is no such thing as investment treaty law. What we call, for convenience, investment treaty law is in fact pure public international law. It's generally customary international law, although there is some convention. And it revolves around the macro issues of state responsibility that have been in existence for hundreds of years. And in particular, it tends to deal with the treatment of aliens. That's what it's called in public international law. Us foreigners, for example, I live in the United Kingdom, I'm an alien in the United Kingdom in public international. It doesn't mean I have green skin and fly around in a Martian spaceship, but that's what public international law calls foreigners in different jurisdictions. So it's the area of public international law that deals with state responsibility related to the treatment of aliens and their property. And it's a very important area of public international law, but it is part of the whole wider body of public international law. And as we know, there's no system of precedent in public international law, but nonetheless, there are some very interesting thoughts and guideposts that are coming out from some developments of the law in this area, arising sometimes from awards in investment treaty arbitration, and sometimes from mutual discussion and agreement among states as they, for example, revise their obligations as they may exist in treaties and public international law. So this is a fantastic moment in time for us to discuss this issue, because what with the European Commission initiative of intra-EU BITs, China's development of the Belt and Road, and all that implies for investment and dispute resolution, and many other issues. This is a timely topic. So with no further ado, I'm going to hand over to Roland, and then we'll have Inga and then Louise. They're each going to speak for about 15 minutes, and then we have time left afterwards for question and answer, and I'm sure there'll be many questions coming along. I know I have some already. So Roland, could I turn to you and ask you to start things off for us? I think you need to turn on your microphone.
Yeah. Good morning, good afternoon, all. I would like to start by thanking Robert for your kind introduction. Thank you, Robert, and thanking ITF and Yarik for convening this panel on such a topical subject. I'm happy to be with you today, although remotely, to discuss all these issues. As suggested by the organizers, my role on this panel is to provide some overview from a state's perspective on the interplay between international investment law and the state right to regulate. I will do so mainly in the guise of legal counsel representing a state. As you know, over 2,500 investment treaties are in force today, and many are signed or renegotiated each year. They are still perceived by a majority of states as a useful vehicle, at least when well balanced, to promote foreign investment in their countries and to obtain reciprocal protection for their own nationals' investment in other countries. Nonetheless, they may encroach on the state's sovereignty, although through the perception that they can hinder policymaking in view of potential investment claims. This is often referred as a regulatory chill mentioned by Sylvie in her keynote speech. And indeed, in concluding BITs, a state in principle subject its sovereignty and freedom to regulate to certain limitations. The risk for a state is that the protection it guarantees to foreign investors may turn out to be more to the detriment of its own regulatory powers than it bargained for, especially if the new or innovative interpretation of the scope of a BIT protection are applied by arbitral tribunals. That is why a state confronted with an investor claim under a BIT and the State Council would normally strive to ensure that the state power and right to regulate is respected to the broadest possible extent, and that the limitations on such powers and rights go to the farther than intended, do not go to the farther than intended by the state when it entered into an investment agreement or a BIT. This is all the more important in a context in which the borderline between protection from political risk and undue interference with the legitimate domestic policy is increasingly blurred. I will first discuss some illustration of how a state and its council would try to ensure a narrow interpretation of the state consent, and then I will discuss different ways states are trying to ensure broad scope substantially to their right to regulate. As we all know, a state may have a variety of jurisdictional, admissibility defenses or objection to any investment claim. And this is no less true when the claim involve state regulation. The state will seek to ensure that an arbitral tribunal applies a rigorous and strict construction of jurisdictional limitation and disability of any claim under the relevant BIT. We all well recall, for example, that amidst the public outcry generated by Philip Morris' high-value investment claim against tobacco plain packaging measures in Australia, the state actually prevailed on the basis of its objection that the claims were inadmissible as being an abuse of right due to untimely investment restructuring for the overt purpose of trying to benefit from the BIT. As state counsel, one would usually argue for a strict interpretation of the definition of investor under the relevant BIT, with only claims from person, physical or moral, who duly meet and continue to meet all the criteria to qualify as an investor under the BIT. States are likely to rely, for instance, on any substantial business requirement or any denial of benefit clause to exclude mailbox companies from investment treaty protection with the aim of curtailing treaty shopping by investors. States are also likely to seek the exclusion of dual national from the protection offered, arguing that protection of foreign investors and their investment mean they must truly be foreign to the host state. Indeed, dual nationals are excluded from the benefit of investment protection, as you know, under the Exit Convention, as well as under certain recent BITs, but this has not always been consistently applied in non-exit arbitration. Another approach which has to some extent emerged is to allow a dual national to bring an investment claim against the host state when his or her dominant and effective nationality is that of the other contracting state. However, a few cases have gone even farther in simply recognizing claims by dual nationals. From the perspective of states, there is a similar interest in arbitral tribunals applying narrow, strict interpretation of the material subject matter jurisdiction requirements so that the scope of protected investments is as narrow as explicitly agreed to under the relevant BIT. Here again, arbitral tribunals also have taken different approaches to defining an investment protected under a BIT. States would normally advocate for an objective approach, or at least for application of the so-called Salini test, even in non-exit cases, meaning that an investment, irrespective of the precise definition in the BIT, always need to have at least some basic features such as a certain duration, an assumption of risk, and a contribution to the economic development of the host state. Some recent model even BITs expressly include such tests or a similar restrictive definition of protected investment, such for instance, the new Dutch and Colombian BITs. In addition, states would seek to invoke in the jurisdictional debate any provision that allows for an unclean hands argument, basically saying that investment obtained through, for instance, fraud deserve no protection under the BITs, and that's something provided sometime expressly in recent BITs. And similarly, states also often invoke, also in the jurisdictional debate, any provision that requires that the investment is made in accordance with the local laws. The state consent to arbitrate investor claim pursuant to a BIT is also predicated, as you know, on the investor complying with various procedural requirements. The state will argue for strict investor compliance with, for instance, any exclusive choice of forum clause, exhaustion of local remedy requirements, fork in the road clause, as well as with any notice requirement of the BIT and any post-notice cooling off period prior to the initiation of the arbitration. Also, states will argue that the consent to arbitrate cannot be construed by means of a MFN clause. States will oppose the idea that investor-state arbitration clause can be imported from one BIT into the other on the basis of an MFN clause. States would argue that otherwise, commitments and offers of protections made to some treaty partners may easily filter to the others with unintended, unexpected, and unacceptable consequences. Likewise, states will advocate that the scope of the arbitration clause cannot be further broadened by means of an expensive interpretation of an umbrella clause in a BIT, and that the intention of the state should not be distorted. The state may argue, for example, that an umbrella clause cannot bring within the scope of the investment arbitration claims based on a contract not entered into by the state in its own name. Now, going beyond the foregoing issues and questions of consent to arbitrate, jurisdiction, and admissibility, as a matter of first principles, a state and its council will usually take the position that the state's broad power to regulate is only limited insofar as investor protection is concerned by the protections it has specifically agreed to in a BIT or otherwise under applicable international law. This is also acknowledged in the standard developed over time in respect of fair and equitable treatment clauses. Tribunals have begun recognizing the state right to regulate in the public interest while assessing the investor right under the FET standard. To this end, tribunals have acknowledged as early as already 20 years ago the state ability to modify its law and regulation as part of the right to regulate. For instance, to take one example, the tribunal in the Saluka versus Czech Republic held that no investor may reasonably expect that the circumstances prevailing at the time the investment is made remain totally unchanged. In order to determine whether frustration of the foreign investor expectation was justified and reasonable, the host state's legitimate right subsequently to regulate domestic matter in the public interest must be taken into consideration as well. Furthermore, states are, as a general matter, afforded police powers to regulate in the public interest. Protection of public health and welfare figure among the legitimate ground for such regulation. These are considerations obviously at the forefront these days, as confronting the COVID-19 crisis has seen states implementing wide-ranging measures aimed at protecting public health, as well as, I would say, many other measures to address the economic and social consequences of the health pandemic and the consequences of the state's own measures to control it, from lockdown to prohibition on certain business activities to travel restrictions. However, such police powers are not unfettered. Arbitral tribunal note, for example, that the state measures must be taken bona fide for the purpose of protecting the public welfare, must be non-discriminatory and proportionate. And we see that even in this wording in some of the recent treaties. There are an ample example where this doctrine applied. The use of the police power doctrine has seen tribunals hold, for example, that a state's ban on a fuel additive harmful to public health, Metanex against US, or a state prohibition on sale of an agricultural insecticide harmful to human health and the environment, Chemtura versus Canada, were considered valid exercises of police power and thus did not constitute expropriation. I mentioned earlier that Philip Morris claims against Australia was defeated on jurisdictional or admissibility grounds. However, as you know, Philip Morris investor claim against Uruguay's measures to regulate also the tobacco products were defeated on the merits. An exit tribunal holding in 2016, I think, that the measures were a justified exercise of police power and not an expropriation. Among the options to reduce uncertainty regarding states' liability and to preserve its right to regulate, I can mention qualifying or clarifying the FET standard and the indirect expropriation clause in treaty, which is increasingly occurring in a number of recent model treaties and BITs, and a few examples provided by Sylvie earlier. The state may also enhance its regulatory flexibility and defend against an investment claim based on express exceptions or carve out from treaty protections or exclusion or exemptions or derogations or reservations contained in a BIT. Examples include the CPTPP, the Dutch, again, and Colombian model BITs, and the draft EU-Vietnam FTA. The most common types of general exceptions or carve-outs include national security, essential security exceptions, or exceptions for measures necessary to meet stated objectives such as the maintenance of public order or the protection of essential services like health, education, water supply, or legitimate public policy objectives, again, such as environmental objective with the climate change issues and cultural objective diversity, for instance. Also, some BIT include exceptions or reservation for specific sectors, such as sensitive or strategic sector linked to the host state prerogative like nuclear energy, defense industry, or natural resources, or specific types of measures, for example, taxation or prudential measures to maintain or restore financial stability. Going beyond this approach, special tobacco carve-out have been included recently in the TPP S2 ISDS and in two other recent agreements, the Singapore-Australia FTA and the Singapore-Kazakhstan BIT, giving the host state the option of denying ISDS with respect to a claim challenging a tobacco control measure. And this is believed to be the main instance so far of investor protection agreement providing a state with the ability to avoid ISDS altogether on a case-by-case basis when a dispute arises, as opposed to giving the state a defense to an investor's claim for reasonable regulation in the particular area. Finally, the state right to regulate may also be protected through the recognition of relevant defenses, obviously under customary international law. Of the 6 defenses recognized under the ILC articles on state responsibility, the defense of necessity may potentially be most pertinent to certain state regulation, though it cannot be entirely ruled out that a state might also invoke self-defense, countermeasures, or even distress as an attempt to justify for certain regulation, action, regulatory changes. However, it is difficult for a state to meet the high standards for making out the various ILC defenses usually. That said, from the perspective of states and their counsel, this is at least potentially another tool in the state toolkit of arguments in defense of its right to regulate. To conclude, as I see time is running, I might make a brief reference to the frustration some states have felt in having the foregoing matter decided by arbitral tribunals under the types of BITs that prevailed for a number of years, with backlash resulting in some states rethinking the scope and specificity of their BITs, others looking to move away from arbitration as the means of dispute resolutions for such claims, and others even reconsidering the use of such treaties altogether. In this context, the need, the necessity to better balance the state right to regulate against the investor right to be protected has therefore become a trend, a challenge, and a priority for all stakeholders, and cover both the procedure and the substantive aspects of investment treaties. Thank you.
Well, Roland, thank you so much for that authoritative and comprehensive overview. A very thorough analysis and sets us well now for our next speaker, Inga Martinkute, who's going to move the discussion along, focusing on a relativist comparative approach. Inga, please.
Thank you, and hello everybody, colleagues and friends. Today I wanted to talk about the right to regulate from a comparative perspective. And I think everybody participating in this forum agrees that currently ISDS as a system and investment law, even if we can define it as such, is undergoing really very complex challenges that probably even amount to existential crisis. It's quite difficult to ignore the demonstrations outside on the streets against the free trade agreements, against this investment arbitration, It's difficult to ignore termination of the treaties and frequent withdrawals from the system by states. Probably it's not surprising that because of all this, there are some initiatives that try to reform the process, the substance, but some other parts of the system just continue operating as if nothing is happening and nothing is wrong with the system. I feel very often that at the heart of this clash, there is a great deal of misunderstanding and miscommunication happening between different stakeholders. And I'm not even mentioning diametrically different interests of those stakeholders that they represent. Fierce arguments are made on both sides, how investment treaties have to be interpreted and applied. Claimants and respondents sometimes seem to be speaking on different languages, both literally and metaphorically. Claimants would say something like, we want a state to pay for obvious, irrational, and arbitrary decisions, diminishing our value of the investment. Or they would say, we want to check the abuse of power of states. While the states would say that we want to be able to regulate for the general interest of the society. And it seems that the pinnacle of those claims and disputes and accusations from both camps, there's this concept of the right to regulate, which is obviously a customary law concept. Of course, states have a right to legislate and to set the rules for the business and economy within their own territories. But we are not talking about outright thefts and probably completely outrageous behavior that we probably were reading about after the Iranian Revolution or somewhere else that have a violent element. Probably what we today together discuss are those subtle regulatory changes to the business environment and how investors and just normal people, how do they conduct business and how can they enjoy their investments and reap the value and the profit from their investments. So when I was researching and thinking about how to identify, so what is the problem, I very often returned back to different legal traditions and legal systems, trying to find the solutions. How do they regulate similar conflicts? How do they resolve similar balancing questions? And that's where the comparative method kicks in and becomes useful, because there's an obvious parallel how investment regime operates and how property is protected under the national legal systems. And Jarek correctly noted that I think the importance of national legal systems has to be acknowledged, and it was inadequately recognized in the previous investment arbitration practices. And for very simple reasons that investment protection as such, it originated from the alien property protection. So there's a historical link. Also, there's philosophical and economic link between how property is protected and how investment is protected. The justifications, not only philosophically, but also, why do we have property? Why do we protect investment? Those are also very similar. And, if we can check whether the property system is operating soundly, we also should be able to check whether investment protection system and regime is operating efficiently and for the interest of all the stakeholders. Also, we should not forget that most of the definitions that are used by investment treaties, they also derive from a national legal systems. And very often the terms, the concepts that are used in the treaties in the investment arbitration practice, they have very heavy national connotations. And those understandings are inevitably export to the international level anyway. So we cannot ignore national law. You know, we have to turn to it and to pay due attention to it. But probably some of you listening could be asking why international lawyers should be bothered at all with national law. They could say something like this, that the treaties define the standard. Treaties have definitions, we just interpret and apply the treaties, and we don't need national law. On the contrary, we want to avoid national law because all the problems that apparently, you know, we face are because the national understandings of property are so different. So what investment law is doing is trying to unify that protection standard and to provide some universal protection for the investment. So, you know, to this, I want to kind of limit the scope of my intervention here. I do not want to argue for the national standard. What I'm trying to help with this comparative perspective is to better understand the backlash, to better understand the legitimacy crisis of the ISDS and investment law. And hopefully, if we can better understand it, we can probably find better ways to resolve it and move forward. So for all these reasons, I think it's valid and actually necessary to look at how different states regulate national laws and how do they protect property, and whether any parallels and could be found with the protection of investment. So speaking in generally, after several years of intensive and detailed research, I was making a comparison and a kind of a sliding scale of different jurisdictions and legal traditions and how they compare against investment protection. And what I've identified are two opposing sides that I call individualistic understanding of property and the societies and states that favor a communitarian understanding of property. And I will explain a little bit with examples, what do I mean, and how it relates then back to the investment arbitration practice and generally investment law. So at the one end of a spectrum, we have those states and societies that are very individualistic, and in their mindset, the property exists primarily to satisfy the interest and wishes of the owner. And probably it's not a big surprise that those individualistic countries also are very often Western countries and developed countries. They have this idea in their history, in their ideology about the value of individual rights. And this concept of individual right and protection of individual rights, it even originates from the time of revolutions. Most of those societies, they either dethroned their kings or decapitated them. And in that way, they limited the absolute, the powers of the absolute monarch in their societies. And very usually that struggle was carried also or driven by the need and the wish to protect private property. So we have the historical tendency to favor the individual right versus the communal interest, whether the society. So what happens in, you know very well, in UK, in USA, because of this ideology, individualistic ideology, whenever there is a general interest that is needed, or like general interest of a society to preserve environment, to safeguard health, or to set up a proper functioning market, whenever there's a general interest of the society, if this general interest transforms into some kind of legislation, regulation, and if that regulation affects one or two or a few individuals, if that regulation diminishes the value of their property or their assets or investments, usually in individualistic societies, it is required by the law, there's such a tradition, that those individuals affected will be compensated. And that's how it works. On the other hand of a spectrum, I identified a group of companies, quite large in terms of territory and population, who have more communitarian understanding of property and ideology and the outlook towards the world and towards how the business should be operating. So in those countries, you know, if you look back again at the history, they probably never had revolution that limited the absolute powers of a monarch. So they never had this tradition of setting the limits to authority or not allowing the authority to intrude into individual rights or diminish the value of private property. So they rarely have that element. In addition, very often they emphasize the interest of the community and society, and they prioritize the interest of general society over the interest of private individuals. So what happens, and I'm now talking in very general terms, that in those societies, the general interest prevails over individual interest in a way that they don't really pay compensation in situations where there's a general regulation and that infringes on some rights or some aspects of the individual right. Okay, so now upon explaining those two ends of a spectrum, you can probably already recognize, you know, some states are predominantly more individualistic and other states are more communitarian. But, you know, it's not so clear cut. Those ideologies, they fluctuate over time. So you might have, for example, in the 19th century US, very libertarian or like liberal, but then probably in the 1900s, there would be certain periods of time when the communitarian interest gains ground and becomes stronger. And then the Supreme Court would then rule in a series of cases that certain regulations that, for example, prohibit producing of alcohol in the middle of Chicago or prohibit operating of slaughterhouses in the middle of the city, that those types of regulations are permissible without compensation, despite diminishing the value of any particular property in that area. Right. So over time, they fluctuate. And even in different areas, the dominant outlook would be different. So what I identified, there are differences how the Europe and US treat environmental matters. For example, I think US is more lenient or like more tolerant on the urban planning and zoning regulation. They would not compensate those kind of planning decisions, while Europe would be more tolerant on environmental regulation. If environmental regulation prohibits certain kind of business or activity, they tend not to compensate those. So in those terms, you can see a lot of differences around the world, depending on the stage of the development and depending on the legal tradition and history and myriad of all other reasons, how those this right to regulate might be understood very differently. And it's not a surprise and wonder that those types of disputes, they erupt in investment arbitration. Because people harbor those very unconscious understandings how certain case should be resolved. And it becomes very sensitive when the arbitrator comes from one or different tradition, then they will have very unconscious bias about how regulatory disputes should be resolved. And because I'm limited in time, and Robert is pointing to the watch. I think I have to pass the screen now to Luis.
Well, Inga, thank you so much for covering a very important issue, which is, of course, that whilst public international law is a single, unified, and generally unvaried global system of law that applies to all states equally, obviously there's some regional variations that don't apply to our discussion today, nonetheless, a significant amount of public international law requires reference to domestic law and is informed by domestic law, particularly in the commercial sector. And as you point out, there are different approaches to many of these issues. And I look forward to many questions from the audience about this. So thank you very much, Inga. And now we turn to Louise, and I understand she's going to be helping us contextualize this, looking at some of the recent awards that have come out from investment treaty arbitrations. Louise, please take the floor.
Thank you, Robert. I'm going to try and put some slides up if technology will allow me. So if you just bear with me for 1 second. Okay. Can I just check that you can see my slides?
Yes, we can.
Thank you. Okay. So first of all, I'd just like to thank Bickel and Bickel for hosting, and Jarek and his team for organizing today. And I'd like to thank Robert for the glowing intro about half an hour ago. As the title slide suggests, I'm going to speak about the meaning and scope of state regulatory powers in international investment law. And in doing that, I'm going to consider first briefly what, if any, definition there is of state regulatory powers. I'm then going to move on to look at state regulatory powers in the context of indirect expropriation. I will then consider the role of state regulatory powers in FET claims. And then finally, I'm going to look at the scope of tribunals' ability to limit state regulatory powers. So starting with the definition, and Inga and Roland have touched on this in their presentations as well. But obviously the right to regulate has its genesis in the concept of state sovereignty, and without that right to regulate, states would be unable to perform many of their functions without incurring liability towards foreign investors towards whom they had assumed obligations under investment treaties. And although there's no hard and fast definition, the regulatory power of states under international investment law is generally understood to be a legal right exceptionally given to the host state to regulate in derogation of the international commitments it may have undertaken by means of international investment agreements without incurring liability towards or a duty to compensate foreign investors. In other words, the right of states to deviate from their investment commitments for public purposes, such as, for example, health, the environment, etc., again, without incurring a duty to compensate. And in an oft-quoted passage in Saluka in the Czech Republic, the tribunal actually sort of neatly summarized the difficulty one has in defining this concept very sort of finitely. And the tribunal there said, international law has yet to identify in a comprehensive and definitive fashion precisely what regulations are considered permissible and commonly accepted as falling within the police or regulatory power of states and thus non-compensable. And it goes without saying that in concluding international investment agreements, states undertake certain obligations vis-a-vis foreign investors, which can or might significantly limit those regulatory powers. So if we move on to have a look at state regulatory powers in the context of unlawful expropriation, the question that the tribunal will have to grapple with is whether or not it's looking at a compensable indirect expropriation or valid non-compensable regulation by the host state. And it's generally understood that there are two main approaches to this issue. There's the sole effect doctrine, which is often seen as more investor friendly. And that's where the regulatory purpose, no matter how legitimate, is irrelevant. And it's the effect of the measure alone that is considered to determine whether an indirect expropriation has occurred. In other words, has there been a substantial deprivation? And this can be seen in numerous awards, but examples include Tokias Tokelis in Ukraine, Vivendi, and the Patrick Mitchell annulment decision. And then second, we have the police powers doctrine, or ordre public et loi de police in French, which protects the state's right to regulate in such matters as maintenance of public order, health, or morality. And this doctrine rejects the sole effects doctrine, holding that protection against unlawful expropriation cannot prevent bona fide regulation in the public interest. And here, measures taken in the proper exercise of police powers may not be considered expropriatory and may not give rise to a right to compensation, even when the investor suffers serious harm. And some argue that the sole effect doctrine should be preferred. Now, why? Well, they say that it's more consistent with pre-existing law in this field, and that it appropriately balances the rights and interests of states and investors. And they stress that the degree of state interference that's required for a finding of unlawful expropriation under this doctrine is very high. Now, the police powers doctrine, on the other hand, it's a bit more of a nebulous test, and when you start to look at the various awards that have dealt with this, you realize that it's a sort of shifting animal, shall we say. But there generally seems to be a three-stage inquiry. The first question is, has there been a substantial deprivation? If yes, does the measure in question fall within the mandate of the relevant state agency that sort of, took the action or issued the regulation, and within the normal exercise of the host state's regulatory powers? And if the answer to that question is yes, then you look at the question of whether the measure is, then the question of whether the measure is expropriatory will be dependent on several other factors, and they can include a number of different things which I've listed on the slide, but lack of genuine public being one of them, and a question whether or not the measure in question is discriminatory. And I've seen it argued that the application of some of these criteria is controversial. Some argue, for example, that considering whether there's a genuine public interest or whether the measure is discriminatory actually conflates expropriation with other international investment law concepts and protections, such as the prohibition on discrimination and the potentially wider FET standard. Okay, so just moving on a little bit, I just want to highlight, still staying with unlawful expropriation, I just wanted to highlight the recent decision of Magyar farming and Hungary, and that award was rendered in November last year. This is interesting because it appears to suggest a recent narrowing of the circumstances that could exempt states from the duty to compensate in case of indirect expropriation, as follows. The tribunal said that it generally accepted measures of police powers that aim at enforcing existing regulations against the investor's own wrongdoings, such as criminal, tax, and administrative sanctions or revocations of licenses or concessions, would constitute one such exemption. And the other would be regulatory measures aimed at abating threats that the investor's activities might pose to public health, the environment, or public order. And that second category really relates to measures such as the tobacco plain packaging regulations or the prohibition on harmful substances, for example. And in that particular case, the tribunal found that Hungary's 2011 amendment to its agricultural and landholding laws didn't fall into either of those categories, and so there was an unlawful expropriation, and compensation was therefore payable. Moving on to have a look now at fair and equitable treatment and state regulatory powers in that context. Obviously, the usual investor argument goes along the lines that the state's obligation to provide fair and equitable treatment encompasses an obligation to maintain a stable and predictable legal framework. And two recent awards that I'm just going to mention briefly here address the interaction between the right to regulate and the obligation to ensure fair and equitable treatment of investors. The first is the Green Tech Energy and Italy final award from December 2018. And that was an ECT claim concerning Italy's reduction of incentive tariffs in the solar electricity market, which the claimants argued caused harm to their investments in solar electricity plants. And Italy's assurances as to incentive tariffs were described in the award by the tribunal as non-waivable guarantees. And the tribunal also held that the specificity of the assurances given by the state were actually relevant to determining whether or not there was a breach of the standard. And in that award, the tribunal essentially held that when repeated and precise assurances have been given or commitments made to the investor that the regulatory framework will not change, then a violation of the FET obligation may be found. And that sort of in some ways echoes the Total and Argentina decision, where the state had purported to make contractual, bilateral or similar undertakings that the tribunal found were binding in their own right. And the second recent decision that I just wanted to touch upon was the Hydro Energy in Spain decision on jurisdiction liability and directions on quantum, and that was issued as recently as March this year. And in that one, again, an ECT claim arising out of Spain's implementation of measures modifying the economic and regulatory regime governing hydropower. In that one, the tribunal essentially held that changes to general legislation are not prevented by the FET standard per se, provided they do not exceed an acceptable margin of change in pursuance of the public interest. Now that begs the question immediately, what is an acceptable margin of change? The tribunal noted that the claimants did not receive any specific commitments or assurances in the legislation or otherwise that there would be no changes to the relevant regime, but nonetheless concluded that it, and I quote, "It does not follow that the respondent was free to make radical changes to the regime without incurring liability." And the tribunal went on in that decision to say that legitimate expectations of an investor that the legal framework will not be arbitrarily changed and that commitments will be observed do not mean that an investor is protected from any change. And in the end, the investor's claims in that one were partially upheld. So moving now to look at the scope of the tribunal's ability to, shall we say, limit or interpret state regulatory powers. Against the backdrop of the growing criticisms increasingly made of ISDS, a question is often asked about the legitimacy of tribunal's ability to limit the scope of state regulatory powers in its findings. And in this context, I think it's important to take a step back and look at the wider context, remembering that the ISDS system is a creation of states and that tribunals derive their authority to adjudicate these disputes between foreign investors and host states from the treaties themselves to which the states are parties, and that states are free to elaborate on treaty standards of protection and the limits placed on state regulatory powers in their investment agreements. Investment arbitration tribunals' scope to assess state use of its regulatory powers is also limited in the ways I've set out in the slide there. But for example, tribunals are not permitted to substitute their own views of either the appropriateness of the measures taken or of the characterization of the situation that prompted the measure in the first place. Before handing back to Robert and to the wider group for discussion, I just wanted to touch briefly on, I suppose, some of the current trends. We're obviously seeing a growing criticism by states and non-state actors of ISDS as being imbalanced and resulting in states' withdrawal from international investment agreements or reform of existing agreements. We're also seeing formal recognition of the right to regulate in multiple international investment agreements, and this is largely considered a positive development. Not only because it makes for a more balanced system, but it provides guidance to tribunals in interpreting these questions, and in limiting their ability or the extent to which they feel able to restrict the scope of states' regulatory powers. One obvious example is the 2016 EU-Canada Comprehensive Economic and Trade Agreement. And then finally, and Roland mentioned this in his presentation at the beginning, but regulatory chill. So where we see governments failing to enact or enforce legitimate regulatory measures for fear of ISDS claims being brought against them. And Roland also mentioned the Philip Morris examples, and although the states were ultimately successful in those, there was nonetheless reported impact, for example, on New Zealand's plans for plain packaging legislation as a result of that. And I think the New Zealand government was quoted as sort of acknowledging that in part they were awaiting the outcome of the Australia Philip Morris decision before taking those steps. And then I thought I'd also mention in this context, although slightly different, the Newmont Mining Corporation in Indonesia case. And that was one in which Newmont Mining in 2014 brought an ICSID claim against the Republic of Indonesia under the Indonesia-Netherlands BIT. And that was as a result of the Indonesian government's plans to instate regulation banning unprocessed mineral exports. And Newmont filed its claim and then promptly withdrew it around a month later, but only after it had reached an agreement with the government of Indonesia, which essentially granted it exemptions from the new mining law and meant that it wouldn't be subject to this ban. And it's particularly interesting because the then Environment Minister of Indonesia expressly acknowledged that these exceptions had been allowed to Newmont Mining as a result of the filing of that claim. And because Indonesia was not able to compensate investors as a result. So that's all I had. I'm going to hand back now to Robert, and thank you all very much for your attention.
Super, thank you so much, Louise. And it's always useful to see how these issues are being dealt with in actual cases, courts and tribunals. So that was a great way to round out our panel.